Okay, joining me now is WBZ's legal analyst, Katherine Loftus. Katherine, what just happened?
Well, Kristina, I think something happened that most of us did not expect. And it's difficult because we don't have all of the information just yet. Obviously, we have to wait until we hear from the defense potentially before next week's hearing, or if there's any additional information that comes out. But what I gleaned from this, when Attorney Brennan moved before the court to exclude the ACA experts based on a Rule 14 discovery violation. And I think there has been some confusion about what that actually means. Many people took it to mean that the Commonwealth was basically asserting that they weren't qualified. That's not what Attorney Brennan has been asserting. What he's saying is essentially anytime there's an expert who testifies, either party is entitled to discovery relative to that expert. And the issue specifically with this expert is, or these experts through ACA, that they've already previously testified, but presumably they were testifying in a somewhat in a limited capacity based on the federal investigation protective order that was issued by the court in Judge Casper in federal court that the Norfolk Superior Court, both the judge and the parties have to comply with. So what Attorney Brennan has essentially said is that when the ACA experts were testifying last year, that the defense, per Attorney Jackson, stated in court to the judge that they had no prep with these witnesses. There was a reading by Attorney Brennan of the actual transcript that happened last year. And essentially what was said at the time was Attorney Jackson said that the ACA experts were hired and paid by the FBI, by the federal authorities, and that they were only allowed per the order to cooperate with them relative to getting their schedules and their certifications, things like that, but they were not permitted to prep with them. And when the judge asked at that time, back in June of last year, am I to believe that there's witnesses that the defense is going to call that there's never been any communication between you? That apparently per the transcript, Attorney Jackson said, essentially that's it. What Attorney Brennan has now asserted in court is that at least it appears to be he's alleging that there is a misrepresentation by the defense because there have been emails turned over. And it was a little bit confusing about what came from the federal court and what came from the defense. It seemed to be like there was Attorney Brennan at the end clarified that some of the information and emails did come from the defense. So
Yeah,
I'm not.
We'll get to that in a minute.
Yeah. But basically that they had been in contact prior to and had been in much more of a substantive communication, which was barred by the federal court order. What I took from this, that the judge took the recess, came back on, canceled the rest of the hearing. She said this is going to have, I think she used the word profound consequences.
Yes, it gives her grave concern, she said.
For the defense as well as defense counsel. I would assume that she's considering revoking his pro hoc vice and potentially even, it's an interesting kind of analysis. For a large portion of my practice is actually working as local counsel, so I'm pretty familiar with pro hoc vice rules. And if there was a misrepresentation on the record in open court, that certainly would be grounds to pull somebody's admission.
To clarify this for our viewers who aren't lawyers, meaning that the judge would consider basically revoking Alan Jackson's permission to be Karen Reed's lawyer in Massachusetts on this case.
That's correct, because as an attorney, you can only practice in the court in the course in which you've taken the bar, or you've otherwise, sometimes after you've been practicing for a long time, you can basically swear into another court if you've been a lawyer in a jurisdiction for 10 years, things like that. Other than that, what happens in many cases, like Attorney Jackson and Attorney Little, Betterow, Attorney Alessi, they come from other jurisdictions. That doesn't mean they can't practice in Massachusetts, but they have to have the sponsorship of a local counsel attorney, who's David Yannetti, who essentially states, this person is in good standing in all of the other jurisdictions. They're here for a specific purpose. In this case, they should be allowed to work with the defense. I will ensure as local counsel that they comply with all local rules and regulations. And it's pretty pro forma. Pro hoc vice admissions are very regular, often more often in civil cases than criminal. But essentially, he's been admitted pro hoc vice, which means really the court is saying, okay, you can come in for this case, but you have to make sure you comply with all the rules. If you don't comply with the rules, the court has their own, there doesn't even have to be motion of the Commonwealth, it can be sua sponte, to consider potentially revoking that. And if there was a misrepresentation of that information, I would think that would be a serious consideration that she's making right now.
Right. And given that Alan Jackson has really turned into kind of, lead attorney for Karen Read's defense, that would be a pretty stunning consequence.
It would be a stunning consequence. I mean, it's, and the interesting thing is it has a lot more consequences as an attorney separate from the Karen Read case. If his pro hac admission was revoked in this case, that would probably be problematic for him, not only on the bar of California, but if he was attempting to pro hac into other states on different cases, things like that. So the ramifications of that happening, if it were to happen, is actually quite severe in terms of somebody's ability to practice. But I think that's the feeling that I got. Because based on hearing that information, her taking an immediate recess, coming back on, canceling the hearing, that is the inclination that I got from the court.
Right. And that would explain her use of the term profound consequences for
That's
counsel.
correct. And she said not only for the defense, but for defense counsel.
Right.
So, I mean, I took that as Alan Jackson's going to be in the hot seat next Tuesday.
Okay, so let's get one other item out of the way before we move back into the meat of what we discussed, which is what you were talking about. Hank Brennan, special prosecutor, got up there, and like you said, he was arguing to exclude these ARCA witnesses. And he at first said that after much back and forth, he got this series of emails between the defense and the ARCA experts from the federal government.
Right.
And then he read them, and then the recess happened. And then when they came back and the judge suspended the hearing, then Hank Brennan said, I wanted to clarify, these emails actually came to me from defense counsel, not from the federal government. Was he making a misrepresentation? Was that an accident? Do you have any idea what that was about?
I don't. At first I was surprised that if it came from the federal government, how does the federal government have Attorney Jackson's emails? Although they could have been, since ACRA's appears to be a contractor who does deal with the federal government on a regular basis, they could have reached out to them independently, asked for their emails. I mean, there's no privilege in those kinds of emails. I don't think that, I mean, that's a difficult question, but I think if it came from the federal investigation, that has more implications that maybe we don't have to deal with right in this particular instance. But I think even if it came from the defense themselves, it really goes to the substance. I'm not sure that it matters who turned it over, that if the substance of the emails effectively shows that there was a misrepresentation in court, what does it matter whether it came from Attorney Jackson or the federal government? I will say it's surprising to me for somebody to turn over information that could potentially, as an attorney, it's interesting to see that those in fact might have come from defense, because you're really self-reporting that, you did in fact speak with these witnesses prior to when they testified.
Right. And so just so our viewers kind of know some of the context, some of the emails were things like the ARCA experts sending their resume and then also saying, I will testify to this, but if you don't want me to say that, that's fine.
Correct. And it's not that, the world of expert testimony is, it can be a little bit shaky. I think most of us in the legal system understand that there's experts who often testify for the Commonwealth, there's experts who testify the defense. They're familiar with, working with the system, with testifying in different cases. So they know, they kind of guide the lawyers what to ask. You should do this. But the problem in that, it likely wouldn't be a problem if Alan Jackson had not said that they had no conversation. It sounds like there was an outline that was potentially provided, that there were some specific recommendations about what to ask her, or I don't, I apologize because I don't remember the words verbatim, but about, having this sort of impression upon the jury. And so it clearly seems that, this person does have a bias. So I think we really are dealing with two things. It's the substance of whether the ARCA experts have a bias, although I'm not sure that that's really what the purpose of, the larger purpose of, Attorney Brennan's motion would be, because I think from the Commonwealth's perspective, put them on the stand, and these are all questions that you can then ask them on cross-examination to affect or reduce their credibility. But I think, it was a really interesting turn of events. Certainly not one that I expected.
I lost
Sorry.
you for a quick second.
Yeah, sorry.
So essentially, if I'm just going to boil it down, the issue is not necessarily that defense may have coordinated testimony with the ARCA experts. It's that defense represented to the court that didn't happen.
That's correct, because they weren't permitted to, per the federal court order. And obviously it's difficult for us to understand what the parameters of the federal court order were, because all we really know is the representations of the parties, which was where they weren't hired by either the Commonwealth or the defense. You're not allowed to communicate with them. You're not allowed to prep with them. You can basically only schedule them and get their qualifications. So the federal court order forbid any parties from having those types of conversations. So not only is the allegation that it's a violation of that court order, but also then it was a subsequent misrepresentation to the court. That's how I interpreted it. Obviously, we didn't have the opportunity to hear from defense, but I was, a bit surprised if the allegations are untrue. I would expect at least somebody to stand up and address it, even if the court didn't want to hear it, to try to put something on the record.
Whoa. This isn't real.
Correct. I mean, that's my feeling as somebody, who has been in a lot of courtrooms, that if somebody on the other side is making something that is alleging something that is, facially inaccurate, even if the judge is getting off the bench, you jump up and try to get something on the record just to, put the point out there. But I didn't hear anything like that, just aside from the scheduling. So I think that's an interesting kind of.
I want to get into two more things. One is the money issue, because the end of the emails, in the middle of the emails that Hank Brennan was reading, he read something along the lines of Alan Jackson allegedly saying to the ARCA expert something about a retainer. And then at the end of the emails, Hank Brennan said a bill from ARCA was sent to the defense for over $23,000, implying that the defense may have paid ARCA for their testimony.
Right.
I asked Alan Jackson outside of court, point blank, did you pay ARCA to testify? And he said, no, of course not. And I also asked, what was that all about? And he said, I have no idea. What do you make of the money part of this?
Well, I think it goes, there's two questions. One is, when was that bill sent? We didn't hear all the dates of the email. So if this was technically subsequent to the February 6th email from the U.S. attorney allowing both the defense and the Commonwealth to retain ARCA if they wanted to, if there's a bill, if the retainer agreement and bill is after February 6th, I don't think there's any issue. If it's before, I think it does, because again, they're not allowed to have any nobody's allowed to have any substantive conversations with the experts per the federal court order. So if it's prior to February 6th, I think it's a problem. I'm surprised by I have no idea what that is. So, and we don't know who it came from, if that came from the federal government. So, sometimes we are left with more questions than we are answers.
And so even if, you just put that idea in my head for the first time, if that bill was after February 6th, meaning in the last 2 weeks or 10 days or so, wouldn't it have been kind of misleading in the way Hank Brennan read it to the court? I mean, he was reading emails from last June.
Yes.
And then ended that with, oh, and here's a bill. Yeah,
I will say, so if it's after February 6th and the Commonwealth knows, then I would think that's an unfair representation for sure. The question I had was that he specifically said, we have all these kind of piecemeal pieces of information. When the judge asked, there was something else she asked about what the date was, and he said, I don't have dates on any of these. So if he doesn't have a date on it, I think it's a fair issue to bring up because it, it could be before February 6th, it could not. I think if it was after February 6th, I think we probably would have heard that from Attorney Jackson say, of course we retained them after we got the February 6th email, and that's what that's for. So I think the lack of that information probably lends itself to the fact that it's likely before February 6th and not after.
And then lastly, this is not the type of analysis I would usually make you engage in. However, Judge Cannone's behavior did seem flustered,
Yeah.
maybe out of character today. Can you just reflect on kind of her reaction, taking the immediate recess and then coming back and canceling everything?
I mean, I would say that I'm not surprised at her reaction. I think that there are, what most attorneys know, particularly trial attorneys, that criminal defense attorneys, our job is really to go as close to the line as possible without going over. And there's sort of this general understanding that criminal defense attorneys in, their zealous advocacy on behalf of their clients will push the envelope in a different kind of way, right? But what most of us understand is that ultimately there's a hard stop. And I think that if information is being presented to a court that there was a blatant misrepresentation on the record in furtherance of having someone testify in which there's potentially misrepresentation there, it's the courts do not look kindly upon that. It's one, I would say it's one of the highest things that you can't lie to the judge. And that's how it appears. It's and unless we hear anything else, but if that allegation is correct, it appears to be a clear misrepresentation, and judges just do not have any sort of sympathy or capacity for that kind of behavior, particularly in a jurisdiction in which you're not barred into, that you're here at the with leave of the court, and that you've certified that under pains and penalties of perjury in an affidavit that you have to submit with your motion, that you'll comply with all the rules and regulations. So I think I was not surprised. I mean, I honestly had it was the reaction I had was probably similar, because I have not seen anything like that happen in a courtroom where it's a big deal. If it's true, it's a big deal.
Yeah. I would love to ask you about everything else discussed today, but it kind of feels like it doesn't matter.
Honestly, I don't know that it does. I mean, the interesting thing about this case, Kristina, is just I've never seen anything like it, that it's like at every turn we know something's going to happen, but it tends to be not what we expected. And I mean, this is not even sort of in the realm of what I would have expected today. I didn't think we were going anywhere near anything like this, but sometimes these intervening circumstances happen. So that's what we're talking about.
All right. Awesome. Thank you for your time as
Yeah,
always.
of course.
Appreciate it. And we'll talk to you soon.